I'm not a lawyer, but today ended up being the last day of witness testimony in the Florida versus Donna Adelson trial. So let me tell you about the last few witnesses and the moment Donna had to decide if she was going to take the stand or not.
What is your choice?
So the first two witnesses of the day were really called to testify about Wendy Adelson's divorce from Dan Markell. The first witness was Wendy's divorce lawyer, and the second witness was a marriage and family law expert. And they both testified that while Wendy and Dan did have some back and forth in their divorce and their custody battle, overall their fighting wasn't that bad. Well, not bad enough to result in a death, according to them.
Ms. Bailey, how did the Adelson-Markell divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markell's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think, and responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose. They were hyperbolic. He used a lot of inflammatory language. But when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Now on cross, the prosecutor got a little spicy with this expert. The prosecutor highlighted that this attorney's opinion on what's normal in a divorce proceeding means nothing compared to the feelings of the people actually going through the divorce.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
so
but
isn't the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world? Do you agree with that? Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had, something similar to what Mr. Markell would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that? Do they ever get upset about the gibberish in the pleadings? Regardless of whether or not it's going to impact their chance of success in court, it can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question.
The expert goes on to compare the size of Wendy and Dan's divorce file to the size of one of her more contentious cases, and she says that the Adelson-Markel file is smaller than what would be expected in a contentious divorce. But the prosecutor says, yeah, duh, because they killed him.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well-
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended. If that's
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
no, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014.
But at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
I guess my
It's-
response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees.
Now, throughout the day and when that witness was done, the judge was checking in with Donna and her team regarding if she was going to testify. At one point, Donna's defense team asked the judge to let Donna rest up and decide tomorrow if she was going to take the stand. And then they later told the judge something about the audience impacting her decision. Right before lunch, the judge said that he would extend the break so that Donna could make her decision, but child, she still wasn't ready. So the next witness the defense calls is one of Donna's previous attorneys, and she testifies about how she was aware that Donna wasn't doing well mentally and how she wanted to take a vacation to get away. The attorney says that at the time, Donna didn't have a warrant, so she told her the trip was fine. But she also told her that there is a chance you can get picked up at the airport.
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
During that time period when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted. She told us that what she really wanted to do was she wanted, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation. My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case. We had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
On November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the date, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Now, by this point, it's nearing the end of the day, and the judge had enough. He told Donna that she needed to decide if she was going to testify or not.
If there are no other witnesses for the defense, it is time for the decision to be made.
I can tell the court that co-counsel and my client are deep in conversation concerning
I
this.
am capable of seeing that, Mr. Zellman. No narration is needed. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of it.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
The judge is over it.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Very well.
So Donna chooses not to take the stand in her defense, and with that, the defense rests. So witness testimony is officially over for this case, and so closing arguments will begin tomorrow, and then jury deliberations. The jury in Charlie's trial deliberated for about 3 hours before they came to their verdict. So what do you think for Donna? Will the jury take longer than 3 hours or shorter than 3 hours? Let me know in the comments.